publishers, and if I misunderstood the
question. But a motivation for 109 or a motivation for 602?
A motivation for 602. When the conversation turned to 109, Your Honor, not a word was uttered about dividing distribution or divided markets. It was all about this problem.
So on 602, you said that one of the things that they wanted was the segmentation of markets. They got half of it. They got the rogue distributors half. Now, I guess Mr. Olson makes the point, and it seems a good one. It's like, that's a crazy half to have gotten. That's the kind that they don't need because they have a contractual remedy against the distributors. And then they don't get people like, frankly, your client, who are rogue something else's with no contractual privity. And what sense does that make?
Well, it makes perfect sense, Your Honor. Obviously, the industry, at least back in 1976, did not get everything that they wanted. What they got was a much more powerful weapon than a contract. I mean, a copyright weapon gives you injunctive relief, gives you multiples of damages, which you don't get out of a contract remedy. But to Justice Breyer's point, because I think it's an important one, when you go to the history, and I think you are right, Your Honor, that there is exactly one spot in the drafting history where the relationship between 602 and 109 was discussed. It was that conversation between Karp and Goldman, who was the general counsel of the Copyright Office. It's on pages 11 to 12 of our reply brief. It's recited in extensive detail in the amicus brief that Costco submitted. And here's what happened. They got their importation provision, and Karp says, now, wait a minute. I don't get it. You've got this importation provision, and you've got this for sale doctrine. They're at war with each other. Which one wins? They seem to be agreeing that first sale wins, but they realize that there's this problem. And what they do, the general counsel of the Copyright Office says, we obviously haven't thought this through. We need to do more work on this, says the Librarian of Congress. And the next thing that happens, you see it in a red line on page 13 of our reply brief, is that for the first time in the drafting history, the two are reconciled by making 602 subordinate to 109 in exactly the way the Quality King found it to be. So the copyright owners got half the loaf. It may not have been the half that was more important to them, but they got a lot more from the extension of the importation provision.
Mr. Rosenkranz, there's that passage in Quality King, which is, I think it's fair to say, unfortunate to your position. Is your basic view of that passage that it was simply ill-considered dicta that we should ignore?
To put it bluntly, yes. That's my ultimate position. But I do think it can be reconciled with our position. Let's start with the question presented in Quality King is exactly the question that is presented here, and the Court answered it yes. That is, do imports, is 109 applicable to imports? The whole driving logic of Quality King is about 109 trumping 602. And it's only in that Part 4, where the Court is rebutting various attacks on its position, that it gets to that dictum, and that dictum is in the third-tier explanation to one of 5 rebuttals. I believe it can be reconciled, certainly in result. What you had there was the foreign distributor who had only British rights importing directly into the United States. There was never a first sale.
Well, in result, but not in reasoning. The passage specifically says this was presumably not be lawfully made under this title.
And I agree with you, Your Honor. I have an explanation. I offer it tentatively. I'm not sure whether it's right or not, either as to what the Court intended or under the statute. My hunch is the Court was thinking about a scenario where the British publisher only needs 10,000 copies to cover Britain. But instead, what it does is to print 100,000 copies. Everyone would know that that is not authorized. It's not lawfully made under this title because the intent is to send it over to the United States. So it's not lawfully made at that moment. Let me also just mention an important undergirding to our position, which is that our position is the only one that does not make a complete hash out of every use of the same phrase in the rest of the statute. Wiley's reading makes almost all of them nonsensical. So let me just give you an example. Section 110, the classroom provision. Wiley acknowledges this is the result, but doesn't explain why Congress would ever have wanted it. The result is that a teacher can go and buy a Beethoven record and play it to her class if it was made in the United States. But if she flips one past it to the next Beethoven record that happens to have been made in Asia, she can't play that for her class. Or Section 109C, the public display. The Buffalo Cafe owner is allowed to purchase something in the United States and put it up on her walls, let's say a picture of Niagara Falls. That is permissible if it was made in the United States, but off the same retail rack she flips one past if it was made in Asia, it's not permissible. Nor does Wiley explain why Congress would adopt an exception to the first sale doctrine that is not at all about sales, that is only about where copies were made. So a U.S. manufacturer who wants to sell into the U.S. market has this incentive to go and send jobs overseas. It's an irresistible incentive if this Court says the law is what Wiley says.
Has that ever happened? I mean, the Ninth Circuit cases have been around for some time. Has any manufacturer ever moved abroad?
Your Honor, I'm sure it has. They haven't announced it. Now, let me just be clear. The Ninth Circuit came out with its opinion. This Court has intervened twice, so the law has never been settled in Wiley's favor. The courts were split. The moment that a manufacturer learns that this Court says you get what we've called the holy grail of manufacturing, endless, eternal, downstream control over sales and rentals. You can ruin secondary markets that are competing with you. The moment that happens, that will be yet another reason for manufacturers silently to decide that they're headed that they're sending their manufacturing overseas.
Of those courts that did hold the way your opponent would have it, am I correct that only one of them adopted the absolutist rule?
Well, Your Honor, there are only 3 courts of appeals that have weighed in, but yes, the Second Circuit is the only one that has adopted the absolutist rule, and that's yet another problem with Wiley's position. Wiley urges its position as a matter of statutory interpretation, but is refusing to stand by it. The moment it gets past the language of the statute, every argument it makes is an argument that is about tempering, like a skyhook coming down from on high, tempering its interpretation in a manner that is completely inconsistent with the statutory.
The government argues, in effect, for what we might call it a common law adaptation of Bobbs-Merrill.
Yes, Your Honor, which is even creates even more mischief. The government's position, as I understand it, is 109 doesn't have to do any work. In service of giving more greater magnitude to 602, we're going to make 109 completely superfluous because Bobbs-Merrill does all of the work. Now, 109, Congress said it put into the statute. It said it on every recodification to codify Bobbs-Merrill, and the government is now making 109 completely irrelevant, but picking and choosing, deciding that it wants the limitation on us from 109, but borrowing from Bobbs-Merrill some reservoir of law that modifies the for sale doctrine. If there are no further questions, I would
Mr. Rosenkranz, can I take you back to Justice Ginsburg's opening question? Just as a matter of copyright theory, I had always understood copyright a copyright holder has a kind of a bundle of rights. It's not one right that applies everywhere in the world. It's you have your U.S. rights and you have your Chinese rights. You have your rights under each jurisdiction's law. And your position is essentially to say that when I sell my Chinese rights to somebody, I'm also selling my U.S. rights to that same person, because the person who has the Chinese rights can just turn around and import the goods. I mean, that's the nature of your position, isn't it? That your U.S. rights are always attached when you sell your rights under the jurisdiction of another country.
Well, so first, Your Honor, back in 1976, this notion of geographic division was very, very new, so it's not at all clear what Congress was thinking with that, with respect to that. But secondly, no, we're not saying that when the owner sells its Chinese rights to the Chinese company, it is selling all rights. Certainly the Chinese company cannot sell everywhere, but after that first sale, all of the manufacturer's rights are cut off. If I may reserve the rest of my time for...
Thank you, counsel.
Thank you, Your Honors.
Mr. Olson.
Mr. Chief Justice, and may it please the Court. Petitioner's commercial enterprise is precisely what Section 602A1 was enacted to address, an international gray market in copyrighted works. This Court unanimously recognized in the Quality King case that 602A1 encompasses copies of books that were lawfully made not under the United States Copyright Act, but under the law of some other country. 602A is broader than 109A because it encompasses copies not subject to the first sale doctrine, for example, copies made under the law of another country. These are the words of every member of this Court in the Quality King case. Now, referring to it as dicta misstates what was going on in the Quality King case. The argument was that if you interpret 602A and 109A as allowing a defense, a first sale defense, you'll emasculate Section 602A. And so the Court was explaining on page 147 and 148, I believe, why there were three reasons why 602A would have viability. And one of those reasons had to do with direct action against someone that was engaged in pirating, and some of it had to do with bailees and lessees. These are relatively small problems, either otherwise dealt with by contract law or otherwise dealt with by the provisions of the statute. But the third reason for the Court's interpretation and its decision in that case was precisely the case that we're talking about here.
Well, it may be important dictum, but you really want to argue it wasn't dictum? It was the holding of the case?
It was the holding of the case in the sense that it was necessary, the Court felt, and we could, I don't feel I want to spend a lot of time arguing what the word dicta means, but it was a necessary ingredient to what the Court felt was an explanation for why it was deciding the case that it was.
Well, you don't need that.
You don't need that. Your 602A has plenty of meaning. I mean, an American copyright holder licenses a British company to publish the work under British copyright law. 602A says he can't import the books into the United States, period. Now, so there's plenty of meaning there. The question is what happens when he sells it to his bookstore and you or I go in and buy it, and we want to give a copy to our wife when we get back to the United States. The question is, is that unlawful?
Well, if we were reading the provisions of the statute, is that copy? Now, there are exceptions for the books that are brought.
No exception. I take it once I bring back 5 copies and I give one to my son.
There are fair use exceptions, and there's other
fair use.
Exceptions.
Is it fair use?
And there are exceptions for the one that you bring back for your wife.
I'm sorry. Is your reading now that when the library imports in a book or a film or whatever it's importing in, it goes to the customs agent and it says to the customs agent, I don't have the express authorization of the copyright owner, but I'm a library, so I can import this book in?
It says
I'm a person who's bought the book in England and I'm bringing it to my wife. What provision gives me the right to do that?
The provisions in the statute that deal with the libraries talk about importing books
so
for
deal
lending,
with the wife. How does the wife
purposes.
get her book? What provision gives the wife a right under your reading?
With respect to the copy brought in the suitcase to give to a family member or to turn over to someone else?
No, to keep for yourself. As far as I understand your reading, I bought it abroad, I can't import it in.
What I believe that is covered by the various provisions of the copyright statute. And the question is it covered by Section 602A1? Yes, it's an import of an acquired copy. Do you have a defense under the first sale doctrine? And I go to the exact explicit language of the statute. There may be exceptions under other provisions of the copyright law, but the first sale doctrine, 109A, specifically says lawfully made under this title.
The reason what I was trying to bring up, and I didn't do it artfully,
well, and this
is imagine Toyota. All right? Millions sold in the United States. They have copyrighted sound systems. They have copyrighted GPS systems. When people buy them in America, they think they're going to be able to resell them. Now, under your reading, now, this is one of their horribles, I gather,